Thank you everyone for joining us this afternoon on our presentation with respect to the regulatory responses to pollution in New South Wales. My name is Hasti Kalarasagi. I'm the partner in charge of our environment and planning team here at Hunt & Hunt in New South Wales. Today's presentation is being delivered by Jessica Baldwin, who's a senior associate in our area, and she's also a accredited specialist in environment and planning, as well as Adam Kennedy Hunt, who is one of our lawyers, and Taylor Finnegan, who is our graduate lawyer. And this is her last time presenting as a graduate, since she's going to be admitted next week. So if I can pass over to Adam. In the meantime, just going back to a couple of housekeepings. If you've got any questions, please put them in the Q&A function, and we will go and answer questions at the end. As I said, everyone can be on mute and off screen while the presentation is happening. If you think of a question after the presentation and you need to reach us, our contact details are also part of the PowerPoint presentation that you will have. But I will now hand over to Adam so he can start the presentation. Thank you, Adam.
Thank you, Hasti. So on the agenda today will be an overview of the recent amendments to the Protection of the Environmental Operations Act 1997, the main investigative powers available to the New South Wales EPA and local councils, and the main notices that can be issued, including newly introduced notices. We'll also look at a few recent EPA prosecution cases, and finally look at a recent case on executive liability for an environmental offence. So for a bit of context, the Environment Protection Authority, or the EPA, is New South Wales environmental watchdog, which has responsibility for investigating any non-compliance with environmental protection legislation. And this is for the purposes of prosecution or other regulatory action. So the Protection of the Environment Operations Act 1997, or the POEO Act for short, is the key piece of environment protection legislation used by the EPA and local councils to prevent, control and investigate pollution in New South Wales. So this act divides responsibility for regulation of environmental matters mainly between the EPA and local councils. So the local councils are usually responsible for non-scheduled activities. So these are activities that do not require an environment protection licence, and these usually take place within the local government area, whilst the EPA has responsibility for scheduled activities. Importantly, both agencies hold similar investigative powers, can issue fines, and can issue various notices under the Act. So just over a month ago, the POEO Act was significantly amended in response to perceived gaps in the existing regulatory scheme, highlighted by the ongoing EPA investigation into asbestos-contaminated mulch found at various sites across New South Wales. So the key changes that you should all be aware of include that there are now harsher maximum penalties and fines for breaches under the Act. The EPA also has a new power to issue public warning statements. The New South Wales Land Environment Court now has the power to issue prohibition orders, and the EPA can now issue preliminary investigation notices and recall notices. These new notices will be discussed later in the webinar by Jess. So one of the most radical changes to the POEO Act is the increase to maximum penalties for a range of environmental offences. So this was made in response to concerns by the New South Wales government that the current penalties are no longer acting as a sufficient deterrent and do not reflect the proportionality of the crime. So as you can see on the screen, maximum penalties for the most serious Tier 1 offences, such as the disposal of waste with harm to the environment under Section 115 of the Act, have been doubled. These offences now carry maximum penalties of $10 million for corporations and $2 million for individuals, where the offence is committed willfully, and $4 million for corporations and $1 million for individuals, where the offence is committed negligently. Likewise, maximum penalties for Tier 2 asbestos waste offences have also been doubled. these offences include, for example, the unlawful transporting or depositing of waste under Section 143 of the Act. The maximum penalty for a company is now $4 million and for an individual $1 million, with further penalties for each day the offence continues. Penalty notices or fines, which are issued by enforcement officers as opposed to the court, have also doubled to $30,000 for a corporation and $15,000 for an individual for certain first offences under the Act, such as the failure to comply with licence conditions or the failure to comply with a clean-up notice. So for repeat offenders, fines are now $45,000 for corporations and $22,500 for individuals. So this gives the EPA an opportunity to escalate the severity of enforcement action against a person without needing to allocate significant resources and time to commence costly legal proceedings. These changes were also a key recommendation from the Legislative Council Inquiry Report on Mining Impacts in New South Wales, which came out in late 2023. So there have also been some changes to the maximum penalties for resource recovery order offences. So resource recovery orders are issued by the EPA and allow some waste to be beneficially and safely reused, independent of the usual New South Wales laws that control applying waste to land. So for example, there's a current mulch order, which requires that before supplying mulch, the processor must ensure that the mulch does not contain asbestos and is ready for land application. So whilst resource recovery orders have diverted materials from landfills, they have occasionally led to unintended outcomes, such as the recent asbestos mulch debacle, which Jess will get into in a bit later. And these pose significant challenges to the EPA. So the recent changes to the POEO Act will increase the maximum penalties for corporations which fail to comply with a resource recovery order from $44,000 to a whopping $4 million if the offence relates to asbestos, and $2 million for a corporation otherwise. So this represents a tenfold increase. Likewise, the maximum penalty for the failure to keep records or provide test results as required by a resource recovery order has also increased from $22,000 to $1 million if the offence relates to asbestos, or $500,000 otherwise. So moving on, under a new section 319 capital B of the POEO Act, the EPA have broad powers to issue public warning statements on matters of concern if it is in the public interest to do so. So this is similar to the current name and shame register available under New South Wales food safety legislation. So here the EPA can issue public statements regarding substances or activities suspected of contributing to pollution or being conducted unsatisfactorily. It also covers matters deemed of environmental concern by the EPA, including potential risks to human health or the environment, as well as complaints received under environment protection legislation. So this name and shame tool will be effective, for example, where people hire waste removal companies to cheaply dispose of waste, not knowing that these businesses or individuals have a record of illegally disposing of the waste on public land, which then harms the environment. So another recent change under the Act is that the EPA can now apply to the New South Wales Land and Environment Court for an order prohibiting a person from being involved in scheduled activities or applying for or holding an environmental protection licence for either a specified period or indefinitely. So the EPA can do this if it considers a relevant person is likely to engage again or continue to engage in unlawful conduct, or is not a fit and proper person to hold or continue to hold an environmental protection licence. So interestingly, a prohibition order cannot be sought in relation to a public utility that provides an essential service. So this may include, for example, Sydney Water Corporation. So moving on to the powers of investigation. So under the POEO Act, authorised officers delegated by the EPA and local councils hold investigative powers for the purposes of ensuring compliance under the Act. So the main investigative powers include the powers of entry and search, questioning and identifying persons, and requiring information or records. So let's begin by discussing the powers of entry. So for a non-residential premises, authorised officers have statutory powers under Section 196 of the POEO Act to enter and search where they reasonably suspect industrial, agricultural or commercial activities are being carried out, or pollution has occurred or is likely to occur. So this includes entry by foot, vehicle or any other means. On the other hand, access to a residential premises is more limited, requiring either occupier permission or the execution of a search warrant. So an authorised officer can obtain a search warrant under Section 199 of the POEO Act, where they believe on reasonable grounds that an offence against the Act or the regulations is being committed or has been committed at the premises. And these are usually obtained from a local court magistrate. The authorised officer then can use reasonable force and enlist the aid of a New South Wales police officer when entering the premises. So generally speaking, the power used for entry will depend on whether there is a concern by the authorised officer or the authority that evidence may be lost or destroyed. So after lawfully entering the premises, an authorised officer then has broad powers to take samples, examine and inspect anything, take photographs or recordings, examine or copy records, and seize anything connected with the suspected offence. So interestingly, the EPA commonly uses drones as an investigative tool. So drones are capable of capturing aerial imagery or videos of pollution incidents, undertaking compliance inspections, conducting volumetric surveys, and collecting air and water samples to be later used as evidence. So for instance, they may assess the extent of an oil spill on a motorway or investigate water pollution in a remote area. So the authority to enter a premises via a drone, including the airspace of that premises, still requires either a statutory power under the POEO Act, occupier consent, or a search warrant, as with other means of entry. So in a recent case, the EPA obtained a search warrant and deployed a drone over a residential property in Rossmore, New South Wales, responding to allegations that it was being operated as an unlicensed waste facility. So on the screen, you can see the actual drone footage, which was tendered by the EPA as evidence in the court proceedings. This footage revealed multiple trucks delivering demolition waste material, which contained asbestos to the premises. The drone was also able to undertake a volumetric surveys of the waste stockpiles to quantify the extent of the offence. So based on this evidence, the defendant was successfully prosecuted by the EPA at the Liverpool local court and fined a whopping $180,000 with an additional $90,000 for the EPA's legal costs. So moving on, authorised officers also have the power under the POEO Act to require anyone they reasonably suspect of knowing about any relevant matters to answer any questions concerning those matters. So this includes the power to request that a person they reasonably suspect has committed an offence to state their full name and residential address. Importantly, the failure to answer questions without lawful excuse is an offence under the Act. An authorised officer may also, by notice in writing, require a person to attend a specified place to answer questions if reasonably required. Again, it is also an offence to not comply with this notice. So similar to police officers, the POEO Act requires authorised officers to give cautions, warnings and directions to alert persons of the implications of answering the officer's questions and the person's rights. Authorised officers are also empowered to issue written notices compelling individuals to provide any information or records in connection with any matter relating to the EPA's responsibilities under the POEO Act. So these notices must detail the manner and reasonable timeframe for compliance and are restricted to records within the lawful possession of the recipient. So the non-compliance constitutes an offence under the Act, although individuals interestingly retain the right to object to complying with these notices on self-incrimination grounds. Importantly, these notices are usually issued before charges have been brought to ensure procedural fairness to the defendant. I'll now pass it on to Jess to discuss the notices that can be issued under the POEO Act.
Thanks very much, Adam. So there's a number of notices that can be issued under the POEO Act, including cleanup notices, prevention notices, prohibition notices, and now we've got a new preliminary investigation notice as well as a new recall notice. All these notices are separate to any duty to report contamination under Section 60 of the Contaminated Land Management Act that we're not talking about today. But if you're issued with any of these notices or any of the notices that Adam's been talking about previously by the EPA or local council, it's always a good idea to get legal advice. So a cleanup notice can be issued by council or the EPA where they reasonably suspect that a pollution incident has occurred or is occurring. This is an example of an EPA issued cleanup notice. A cleanup notice must specify what cleanup actions are required and the timeline for compliance. Under the recent changes that commenced in April this year, the definition of cleanup actions has also been expanded. And the cleanup notice can require for reports to be prepared along the way, indicating what progress has been undertaken. And cleanup notices issued by the EPA are put on a POEO public register. Sorry, just trying to get to, yeah, there we go. So cleanup notices can be issued to owners or occupiers of a premises, or a person who's reasonably suspected of causing the pollution incident, which is a polluter. So that follows the polluter pays principle. And in section 91, subsection 4 of the POEO Act, there's also a process where the polluter pays principle can be used, where if you're issued with a cleanup notice, but you're not the person responsible for the pollution, you can seek to recover the costs of complying with the cleanup notice through that section. So that might come about if you're, say, the landlord and your tenant has done something on the site that's caused a cleanup notice to be issued to you. So that's one avenue that you can explore. Cleanup notices, there are no appeal rights, but they can be varied or revoked. And importantly, a failure to comply is an offence with maximum penalties up to $2 million, and continuing offence provisions also apply. So what happens after a cleanup notice is issued? So usually a detailed investigation report will be prepared where you'll go and get an environmental consultant to come out and do some on-site sampling that's then sent to an external lab. This can be both soil and groundwater. And then the environmental scientists will then put together a conceptual site model of what they think is happening and put together a remedial action plan that sets out a number of remediation options, which might include something like a cap and cover or on-site treatment. And they'll also consider what level of remediation is required in terms of the future use. So a cap and cover might be where the contamination is left on site and in a clay layer is put over the top and a textile fabric, and then clean fill imported to the site. And then on-site treatment might include something like including lime into the soils to get rid of acid and things like that. But then a validation and monitoring is undertaken, and a site audit statement needs to be prepared by an independent site auditor to confirm that the remedial action plan has been undertaken. There's also, in the changes from earlier this year, there's also a new section 93 capital A that clarifies that development consent is not required to carry out any cleanup actions under a cleanup notice. And if you are doing something like a cap and cover, there'll be a requirement for what we call a long-term environmental management plan to be put in place. And we often provide advice around long-term environmental management plans in terms of their legal enforceability and that they're publicly notified. These are requirements that the site auditor will want to see. So for them to be legally enforceable, you may need to put a positive covenant in place, or there might be a DA condition. And then it will be publicly notified, usually through a 10.7 planning certificate by submitting the report to council, or through DAR before you dig provisions. So another type of notice is a prevention notice, which can be issued by the EPA where they reasonably suspect there's been an activity that's been carried out in an environmentally unsatisfactory manner, which is included in those 4 subpoints there. These can be issued to an owner or occupier or person carrying out the activity, and there is an opportunity to appeal to the Land Environment Court if an appeal is lodged within 21 days. These are also recorded on a public register if issued by the EPA. And some examples include a reduction of noise emissions or undertaking an acoustic assessment in an industrial complex. These types of notices were also used in response to the Sydney mulch investigations earlier this year. So under that, a prevention notice was issued to VE Resources Recovery in January this year, and that has since been complied with and revoked. And so now VE Resources can continue to carry out their business. VE holds an environment protection licence for composting, waste storage and recovery of waste at their premises. And the preventative actions that were required by the notice were to cease any production of mulch products, cease exporting any mulch products, and they weren't to move any of the stockpiles around unless directed to. So the existing stockpiles were disposed of and staff received further training. And then the EPA strengthened the conditions in the Environment Protection Licence, including for further testing for asbestos prior to supplying mulch off-site. And another type of notice is a prohibition notice. These types of notices can only be issued by the minister on recommendation of the EPA. And these are for an emission or discharge of pollutants from or within a premises in which an activity is carried out on that's either causing or likely to cause harm to the environment, is so injurious to public health, or is causing or likely to cause such discomfort or inconvenience to any person outside of the activity that the giving of the notice is warranted. And again, it's offence not to comply with a $2 million up to a maximum $2 million penalty, and continuing offence provisions also apply. And if you fail to comply, the EPA may take actions to cause compliance with the notice. This is one of the new notices, a preliminary investigation notice. So these were introduced in April this year. It's an EPA power only. And preliminary investigation notices can be issued if the EPA reasonably suspects there's circumstances that may pose a risk to human health or the environment. So that's a different test to whether a pollution incident is occurring. And this allows the EPA to step in early and issue a preliminary investigation notice, either written or verbally. And they'll require the assistance of whoever is issued with the notice to help with the investigation. So that might include collecting samples or providing a report or limiting access to a site to preserve evidence. Again, non-compliance provisions is an offence not to comply, and up to a $2 million maximum penalty as well. And all right, the last one is the recall notice, which is the second new notice that's been issued by the EPA. So the EPA, with the approval of the minister, may issue a recall notice if one or more of the following grounds apply. The first is if a substance or a particular use of a substance or activity involving the substance poses a potential risk to harm to human health or the environment, or a substance is required by environment protection legislation or NEPM to comply with prescribed standards and those standards haven't been met, or environment protection legislation has been contravened. So in that case, the recall notice must identify the supply chain participants who are subject to the recall notice. And this can be either by identifying them by name or by reference to a class of persons. The recall notice must specify the actions that are to be taken by the supply chain participants. And supply chain participants can include anybody, including producers, sellers, distributors, transporters, suppliers, or anyone making the substance available for sale or providing to another person. Actions that can be required under a recall notice can be to stop supplying the substance immediately or within a specified time, take action to recover the substance, sampling, testing, remediating, disposing of the substance, giving information on supply chain participants, publish warnings that the substance is being recalled. So that might be publishing the batch numbers or to not produce a substance. The new Act tells us that development consent is not required under the EP&A Act if you're complying with a recall notice, and also that the costs of any recall will be borne by the supply chain participant, and then you're to use existing contracts or other avenues to pursue damages or compensation. And now I'm going to hand over to Taylor to tell us about a couple of recent APA prosecutions.
Yes, so we're now going to look at some recent cases where environmental offences against the Protection of the Environment Operations Act were prosecuted. As discussed, the EPA can bring proceedings for any environmental offence against the Act. As a general principle, where a serious breach of the environmental protection laws comes to the attention of the EPA will lead an investigation and take any appropriate action. So the first case of EPA and Carbon MF Propriety Limited, handed down by the Land and Environment Court in November 2023, is significant as the New South Wales EPA successfully prosecuted for a failure to comply with a cleanup notice. So in this case, Carbon MF operated a tyre processing and storage business from a leased warehouse in Albury on the New South Wales-Victorian border. The company had obtained development consent for tyre processing and storage on condition that the product on site did not exceed a total of 500 waste tyres. On the 9th of February 2022, an EPA officer attended the premises with a volumetric surveyor, and it was determined that there was the equivalent of more than 23,000 tyres on the land. A cleanup notice was subsequently issued to Carbon MF requiring the number of tyres stored at the premises to be reduced to below 500 whole tyres by the end of May that year. During May, however, tyres continued to be delivered to and stored on the premises. On the 17th of June 2022, the EPA issued a cleanup notice to Mr. Fair, the director of the company, that required him to restrict access to the premises while continuing to allow tyres to be removed from the site. The tyres in this case were a fire risk, and if they had caught alight, could have resulted in a serious incident with toxic smoke potentially impacting nearby residents and impeding air traffic at the nearby airport. Carbon MF and Mr. Fair, as a director of the company, were both charged with the offences of failing to comply with the cleanup notice under Section 91 of the POEO Act and the offence of pollution of land under Section 142A of the Act. By that time, there were calculated to be about 28,000 tyres on the land. Carbon MF and Mr. Fair both pled guilty to all these charges. The court found that while there was no evidence of actual harm to the environment, there was a real and substantial risk of potential harm in the event of a fire arising from the placement and maintenance of the tyres on the land. Aggravating features of the offending conduct included that the offences were committed for financial gain and without regard to public safety. The court also found that the commission of the offence was deliberate because the defendants were aware of the requirements of the cleanup notice and could not be unaware of the number and storage of the tyres at any given time. Furthermore, neither defendant was found to have made any expression of contrition or remorse. In light of this, the court determined the objective seriousness of each of the offences to be within the mid-range of objective seriousness. The fine imposed upon Mr. Fair, the director, was reduced by 70% to reflect his strained financial circumstances as an undischarged bankrupt. Ultimately, the defendants were together fined a little over $582,000 and were required to pay the New South Wales EPA's legal and investigation costs. The court also, in this case, made a publication order under Section 251A of the Act. Publication orders are employed as a tool to make the offender accountable, but also to act as a significant deterrent to other corporations committing similar offences. Generally, the court will issue an order that specifically outlines what must be contained in the advertisement, its size, and the method of distribution. In this case, the publication order required a notice with details of the offence and punishment to be delivered to all businesses listed on the company's customer contact list. So moving on to the second case, this is a more recent EPA prosecution case that was handed down in February of this year in the Land and Environment Court, and is Environment Protection Authority and Routledge. So Mr. Routledge was a fuel tank driver employed by Park Pty Limited and criminally charged over a diesel spill. On the night of the offence, the defendant was required to transport and unload diesel into an above-ground storage tank at a petrol station in Barrel. The defendant had only been working for the company for 2 months and had only delivered to the premises once before. While delivering the diesel, the defendant connected the hoses from the fuel tanker to the incorrect fitting pump from the above-ground diesel storage tank. He then proceeded to unload the diesel and walked away from the fuel tanker. While the fuel tanker was out of the defendant's sight, diesel spilled onto the grassed and gravelled area on the premises and into the stormwater drain that discharged into Mittagong Creek. Upon discovering the fuel spill and stopping the unloading, the defendant used a spill kit to try and stop further fuel leaking into the stormwater drain, notified his employer, and followed their instructions. The defendant, however, did not notify any relevant authorities such as the EPA or Fire and Rescue, and it was not until the owner of the petrol station discovered the spill the following morning that the authorities attended the scene. Following the incident, Park was issued with a clean-up notice and Mr. Routledge's employment was terminated by Park for breach of his dangerous goods licence. The defendant pleaded guilty to the offence of pollution of water and pollution of land under sections 120 and 142A of the POEO Act. It was agreed fact that the land pollution and water pollution had caused actual harm to the environment. The diesel had changed the chemical and biological conditions of the water, impacting the aquatic biota of the receiving environment. And the spill also degraded the grass area, causing potential risks to humans, animals, and terrestrial life. The seriousness of the harm in this case was an aggravating feature. The court, however, did reduce the objective seriousness of the offending conduct, having accepted that the connection error made by the defendant was not caused by an inattention or negligence or recklessness, but rather that the defendant was relatively unfamiliar with the premises and process due to having received limited training by his employer, and that all actions taken by the defendant, including leaving the pump unattended, were consistent with instructions he had been given. The objective seriousness of the offence was considered to be in the middle of the lower range of seriousness. The fine was reduced by 70% in account of the defendant's limited means to pay a substantial fine, and ultimately Mr. Routledge was ordered to pay a fine close to $20,000 and the prosecutor's legal and investigation costs. So the maximum penalties for each of the offences in the 2 cases that I've just discussed have since doubled under the changes to the Protection of the Environment Operations Act. As shown in the table here, the penalty for a failure to comply with a clean-up notice or causing of land or water pollution went up from $1 million to $2 million for corporations and from $250,000 to $500,000 for individuals. These cases also highlight how the EPA is increasingly targeting directors, managers, and employees for offences committed by corporations. It's an important reminder of how the culpability of offending conduct can be divided among different parties. For example, in the Routledge case where the driver was personally prosecuted, this was despite the court finding the primary culpability rested on his employer. It is also important to be aware that special offences exist for company officers. In the earlier case, Mr. Fair was prosecuted as a director of Carbon MF under the Special Executive Liability offence. I'm now going to hand it back over to Adam to discuss this offence in some more detail.
Thank you, Taylor. So turning now to executive liability under the POEO Act. So a company officer may be held personally liable for certain offences committed by the company, provided the offence attracts either special executive liability or executive liability. So these provisions are set out under sections 169 and 169A of the POEO Act. So special executive liability does not require proof of fault under the Act and will only be waived where the defendant satisfies the court that they were not in a position to influence the conduct of the company, or the person used all due diligence to prevent the breach by the company. So there are currently 21 offences that extract special executive liability under the Act, which are generally more serious Tier 1 offences, including the use of a place as a waste facility without lawful authority. Company officers also can also be personally liable for less serious Tier 2 offences committed by the company under Section 169A of the Act. In this case, the prosecution must establish that the officer knew or should have known that the offence would be committed and failed to take reasonable steps to prevent it. So there are currently 23 offences attracting executive liability under Section 169A, including not complying with a clean-up notice, which Taylor touched on before. So let's look at a recent New South Wales Land Environment Court case of Crush and Hull to see how these executive liability provisions work in practice. So in this case, Crush and Hull Proprietary Limited operated a quarry north of Coffs Harbour. The quarry extracted, processed and stored at the quarry rock and clay, mainly for the sale to the former Roads and Maritime Services, which was used at the time for the construction of the Pacific Highway upgrade. The company was permitted to handle up to 30,000 tonnes of materials without needing an environment protection licence under the Act. However, in 2018, the company processed over 92,000 tonnes, which triggered the need to obtain a licence. So operating without the necessary licence, the company was in breach of Section 48, subsection 2 of the POEO Act. So this offence attracted executive liability under Section 169A of the Act, provided the prosecution could make out that the company officer knew or should have known that the offence was being committed and failed to take reasonable steps to prevent it. So in this case, both the company and Mr. Couchy, who was the sole director of the company, pled guilty to both these offences. So in determining the appropriate sentence, Chief Justice Preston of the Land and Environment Court found that Mr. Couchy was the central person involved in the management of the company and was in a position to influence the conduct of the company to prevent or stop it from committing the offence. Mr. Couchy had the ability to prevent the quarry from extracting more than 30,000 tonnes without first obtaining a licence, yet he chose not to do so. So the court accepted evidence from the EPA that Mr. Couchy knew about the requirement to obtain an environment protection licence, as evidence showed that he had engaged an environmental consultant to apply for the licence on the company's behalf before the offence was committed. The licence application was later withdrawn by Mr. Couchy and 4 other colleagues due to apprehensions that it would be likely be rejected based on fit and proper assessments. So despite this knowledge of the offence, Mr. Cauchi continued operating and extracting materials well above the threshold for over 6 months without a licence, and only stopping once the EPA had undertaken its investigation. So the court found that Mr. Cauchi's failure to control the conduct of Crush and Hull in this regard undermined the integrity of the regulatory scheme as a whole. So ultimately, Crush and Hull, as the company, was issued with a $250,000 fine, and Mr. Cauchi, as the director, was issued personally with a $22,500 fine. A publication order was also made requiring a notice with details of the offence and punishment to be published in the Sydney Morning Herald and other local media outlets. Both defendants were also required to pay the EPA's hefty legal costs. So this case confirms that company officers may be personally liable for environmental offences under the Act if they fail to take reasonable steps to prevent or stop the commission of offences by the corporation. So that concludes the substantive component of today's webinar. I'll now invite Hasti back to chair the Q&A session.
Thank you, Adam. So we don't have any questions at the moment, but I have a question for you. Were there any other fine increases in other legislation aligned with this Act?
Yes, there were. Maximum penalties also increased under the Pesticides Act 1999. So I think one example was that a person who willfully or negligently uses pesticide, which is found to injure another person or damage property, has increased from $250,000 to a whopping $2 million for a corporation.
Mm-hmm.
There have also been some increases for fines for corporations under the Protection from Harmful Radiation Act 1990, which is now $2 million for a corporation. And under the Contaminated Land Management Act 1997, local courts can now issue maximum penalties of $110,000 as opposed to the former $11,000. So a massive increase.
Great. And what happens if you suspect that you have a product that needs to be recalled? Is there an opportunity to do like a voluntary type of recall, or will you still be fined?
Yeah, so there is an opportunity to do a voluntary recall. If you suspect that there's a risk to the environment or human health, you should notify the EPA, and then the EPA will notify that recall on their website as well. And that doesn't mean to say that the EPA won't issue their own recall notice as well.
Right. We do have a question from the audience, and I might ask Paul to add a bit of context to it. But the question is, can you comment on the insurability of these fines? So Paul, I'm not sure if you want to come on and just maybe provide a bit of context to the question, or if you want to type a bit of context to it. And while we wait for Paul to answer, we've got another question. The second question is, can consultants issue certificates for asbestos removal? Sorry, let me read again. For the consultants who are issuing certificates for asbestos removal, can they be penalized as well?
Yeah, so the way that asbestos removal is regulated in New South Wales is under different legislation. So it'll be under the WHS Act and regulations. And there are definitely provisions there that asbestos removalists who are certifying need to meet. And yeah, that's a different scheme. But happy, if you've got an issue, happy for you to reach out.
Thanks, Paul. Paul's come back. He wants to know if the fines can be insured, because some fines, for instance, for originators in some states are not insurable. And that the directors and companies must pay the fines themselves.
So I think it would probably come down to the terms of your insurance policy, and whether there's been negligence proved and things like that. But yeah, it's definitely something that we could consider in further detail if there's something specific, Paul.
Okay. We have a couple of more minutes left if there's another question. Any other questions? If there are no other questions, thank you very much, everyone, for attending. Thank you to Jess, Adam, and Taylor for presenting today. As I said earlier on, if you think of a question after this seminar, please feel free to reach out to us. Our details are there. You can also find us on the website. And we look forward to seeing you at our next seminar. Thanks, everyone.